Morning. I can't hear you. Hold on a second. Can you hear me? It's always something. Nope.
Okay, how about now? Good.
Yep.
All right. I don't know why there's like multiple options for microphones on my computer, but whatever. It never seems to be the right one selected when I log into Zoom. So thank you again for being here today. This is really
No
great.
problem.
I remember
Forward to
coming
it.
to your fellows talk a few years ago. So this is very exciting to see the finished product.
Cool. Yeah, I tried to change it up a little bit with that in mind because some staff have sat through two versions of this, I guess, because I was here in 2012, which of course it's changed quite a bit since then, but
Right. Well, gosh, even in the last, I mean, we're like everybody else right now that there's a lot of turnover, and we've had a number of staff go to other opportunities in the last year and new folks coming in. So yeah, it's a little crazy. So I'm going to make you a co-host. Let's see here,
okay.
so that you can share your screen. There we go. Okay, so if you want to try out any PowerPoint or images or whatever you've got.
I can.
All right, that looks good.
Good.
Cool.
And I'll let you put that. I guess I stop share and then you can put that other one back up there.
Okay. Yeah. Let's see. Oh, my Outlook is trying to give me notifications now. Okay. So yeah, that looks like that is all good to go. So I will probably I'll just share. I have a, PowerPoint that plays on a loop while people are trickling in.
Mhm.
I might turn my camera off for a few minutes and try to gobble my lunch down really fast.
Oh yeah.
And then I will go ahead and get us started right at noon. And just do like a brief kind of announcements and then introduce you, and you can take it away.
Okay.
And then when you, at the end of your talk, I let people submit questions in the chat and stuff throughout the program, and then we can just save those for the end and have a little discussion afterwards.
Okay.
And then we'll wrap things up. So did I see some relatives of yours on the registration list too?
Probably. Yeah.
I was like, I think they might be related, because they said they heard about the program from you. So I was like, oh, I love that. So
Yeah. Yeah. I was like, I don't have to come, but
my mom loves to come to everything. So
well, it's nice, they live in Florida, and so they never really seen me do what I do, and so with Zoom they're able to now do that. So.
oh, that's awesome. That's awesome. All right.
All right. Well, you go eat your lunch. I will see you soon.
All right. We'll bring it back here in just a few minutes. Thanks.
All right. Bye.
Hi, everybody. It is noon, so I'm going to go ahead and get started. I think we'll probably have a few more people trickling in here. But welcome to First Friday. My name's Carol Easterly. I am one of the museum program coordinators here at the Kentucky Historical Society in Frankfort. We are very glad to have you with us today. And just a few reminders before we get started. Do have people coming in here. Just remember throughout the program to please keep your microphones on mute to help us avoid any noise interruptions. You are welcome to keep your cameras on if you're comfortable with that. We like to see you smiling back at us. And do please use the chat feature down at the bottom of your screen. It's that little conversation bubble button to submit questions and comments throughout the program. We will save those for the end of the presentation, but you can certainly submit them at any time. And of course, just make sure that any comments or questions are respectful of the host, the presenter, and all of the other guests that have joined us today. I want to make sure that you're aware of all the cool stuff that's going on around here at KHS, upcoming events and such like that. I hope you can join us next month for First Friday. We are very pleased to be welcoming Dr. Crystal Webster, who is professor of history at the University of British Columbia. And her work focuses on the experiences of free Black children in the northern United States during the pre-Civil War years. So we're going to be learning about that. Kentucky Ancestors is getting ready to launch our second season. That is KHS's TV show, where we help Kentucky families solve mysteries and answer questions about their family history. And if you haven't gotten to see season 1, if you want to catch up, it's available on our YouTube channel. And season 2 will begin airing this spring in major TV markets throughout the Commonwealth. So if you check out our website, history.ky.gov, you can find out where the best station is for you to watch it. We encourage you to check that out. And of course, it is tax season, yay. But that means it's time for your annual reminder about the Local History Trust Fund. If you are a Kentucky resident or file taxes here, please remember to look for line 38F on your state tax return, check that box, and then donate a portion of your refund to the Local History Trust Fund. It will help support the work of local history organizations all around the Commonwealth. And if you would like more details about how those funds are distributed, as well as stories about the work that your gifts have helped to support in years past, you can certainly visit our website for more information about that as well. And now I'd like to introduce you to today's presenter, Dr. Jeffrey Perry. He's an assistant professor of history at Tusculum University in Tennessee, originally from Sarasota, Florida, and studied for his BA and his MA at the University of South Florida in Tampa, and got his PhD at Purdue University, way up north in Lafayette, Indiana. That must have been quite a change. He specializes in early American history, particularly on the legal and religious history of the post-revolutionary period. We're actually welcoming Dr. Perry back to KHS today. He was one of our research fellows just a few years ago, pre-COVID. And the KHS Research Fellows Program is supported by the Kentucky Historical Society Foundation. We're very grateful to them for that because it helps to connect scholars like Dr. Perry with the resources that we have here at KHS. And it's always really exciting for us to see how they're using the resources that we have here to further our understanding of Kentucky history. And so with that, please take it away, Dr. Perry.
Thank you, Carol. It is nice to be here. I have to thank KHS as well. I see some familiar names in here. Some of you have sat through one or more of my presentations in the past, and I appreciate that. With that in mind, I try to change this one up just a little bit to limit the repeat information. But yeah, I was first a fellow in 2012 when this was literally in its first months. This book was in its first months of sort of coming to be, and to be now 10 years later and having it complete, I'm obviously very happy about that. And my 5 or 6 weeks that I spent at KHS over the years really informed this book from early on. So I am very happy to be back and be taking part in this First Friday. There we go. So the book is called Law in American Meetinghouses, Church Discipline and Civil Authority in Kentucky from 1780 to 1845. And the church that you see here, Fish Trap United Baptist Church of Johnson City, Kentucky, this was the book, or excuse me, this was the church that is actually the inside of the book cover is the inside of this church. This was from a survey in 1973, which was funded by the federal government. I'm not exactly sure what the purpose of the survey was, but this was one of the pictures that they took of the Fish Trap United Baptist Church. And so let's go ahead and get started, if this will let me switch screens. All right. There we go. So in November of 1831, Jacob Creeth Jr. became guardian to the infant son of a recently deceased Sidney Bedford. He also agreed to manage the Bedford's estate. Henry Foster, a fellow church member of Creeth, and two other men entered as securities on Creeth's behalf, all agreeing to serve in that position until the ward Bedford came of age in 1848. Creeth and Foster were both members of the David's Fork Reformed Church, located just outside of Lexington. And after hearing later on, after a few years, that Creeth planned to relocate with his wife, the ward Bedford, as well as slaves to Missouri, Foster made clear that he would withdraw from the contract if Creeth left the state. Creeth refused to release Foster from the bond and claimed that the original agreement made in 1831 made no stipulations about his remaining in Kentucky. So seeking release from his security, Foster sued Creeth at the Fayette County Circuit Court. The David's Fork Church took up the dispute as well, deciding that Foster had committed no wrong by initiating the lawsuit. Having already moved to Missouri and hearing this news, Creeth exclaimed, "If I was still in the neighborhood, I would live and die out of religious society before I would trust my character and property with the church again." Now, most Americans today would not think of their local church as a site for arbitration, and they may be hesitant to bring their property disputes, moral failings, or personal squabbles to their kin and neighbors for judgment. Perhaps fewer would expect a fair hearing. But from the Revolutionary period through the mid-19th century, many Protestants imbued local churches with immense authority, subjecting their private and public actions to congregational scrutiny. Churches insisted that brethren refrain from suing each other before infidels at the local civil court, which is exactly what Foster had done with Creeth, and thus they assumed jurisdiction over a range of disputes typically considered matters for common law, equity, or criminal courts. The expected charges of immorality, such as swearing or drunkenness or adultery, these dominated the disciplinary sessions, but church records are also peppered with disputes over trespass, land, probate, slave warranty cases, and even theft. Church members expected disciplinary decisions to be authoritative, while also arising from impartial consensus amongst the church members. But when this system failed, when discipline failed, the wronged, such as Creeth, often pushed back, and their responses highlight the various forces, religious, economic, and legal, which I claim shaped the law of the church, and ultimately hindered that venue's ability to arbitrate members' disputes effectively. So the book looks at a few different things, and it makes the argument that church discipline, this ritual practice of Protestant churches, I focus mostly on Baptist churches because they're congregational and disciplinary cases stayed local. They didn't filter up into a hierarchical system. But every once a month on Saturdays, church members gathered, and part of this business meeting was to air your grievances and to bring your moral failings to the congregation to judge. And you could be suspended, you could be excommunicated from the church, or you could just be, you can make satisfaction, you can go about your way. So I argue that this system of discipline that took place in meeting houses across Kentucky, but also in other parts of the early republic, was a key venue for the production of local law. That is, this system of arbitration that was set apart from the formal laws that were being issued in state legislatures, And the decisions and the actions taken by these local legal venues, whether they were in a meeting house, a local courthouse, or a tavern, were really embedded in the social relations of the community. And, my sort of intervention is that while historians have been looking at ways that this local law operated in the post-revolutionary period, often outside of formal legal venues, they've largely ignored what's been going on in meeting houses and in this area of church ritual known as discipline. And the book focuses on three questions. So the first one is, what role did this practice of church discipline play within this set time period of roughly the settlement period of Kentucky through about 1845? And there's a noted decline that religious scholars have pointed out that, hey, after 1830, disciplinary cases really sort of begin disappearing from church record books. They become more interested in other matters or whatever. And so I'm looking at why did this happen? What were the forces that led to this dwindling of discipline? And then finally, what did this mean for the broader relationship between church and state, or civil and religious authority? We tend to think about church and state in strictly constitutional matters, as far as the religion clauses of the First Amendment. But other scholars have argued that this was really a cultural process of removing churches from roles of civil and social governance. And so I think that this declining discipline is part of this process that needs to be teased out some. So why Kentucky, which was a question that I got throughout this research process. And the argument that I make is that, building off of a lot of really good scholarship based around Kentucky over the past few decades, is that this was the United States' first frontier. It was largely settled amidst the Revolutionary War in the 1770s and early 1780s. And so, here are Americans moving into this contested territory and trying to play out the ideals of the revolution, liberty and equality and all that, and in a place that's largely free of the baggage of the settled states in the East. And in this case, we don't have in Kentucky in the 1780s a strong church state establishment, even though technically Kentucky would have been considered Anglican since it was part of Virginia, but there's no structure there. So it kind of gives this blank slate to see how these institutions developed over time. Of course, Kentucky is the center of the beginnings of that Second Great Awakening, which kicks off with the camp meeting revivals around the turn of the 19th century. It also, slavery is contested from the beginning, at least until 1799 or so, with the second state constitution sort of implants it. But it remains controversial in some sectors. I guess you could say probably all the way up until the Civil War. And it rents through Baptist church life, Protestant church life, at least through the first decade, to then later reappear later on. The bluegrass region of Kentucky, which is really where this book is focused. I tried to pick churches for my data in and around the greater Lexington area. It's so integrated, it becomes so integrated into this dynamic market economy of the early republic that, ultimately I argue that you can use this region in Kentucky as a microcosm for all these, anxieties and tensions and developments of the United States during this time period. So the book has 5 chapters. It's relatively short. The first looks at the settlement of Kentucky and the role of Baptist churches, and sort of lays the groundwork for how this system of discipline works. The second chapter moves into issues of race and gender, and how disciplinary actions revolving women in the household and free and enslaved Blacks, how that changed over time and what that meant for discipline more broadly. And we're going to look at chapters 3 and 5 today, just sort of briefly. I'm going to give you a little bit of each and tie it together, hopefully, in a way that makes sense. So now, getting back to Jacob Creeth. So in his quarrel with Henry Foster that we saw, Creeth insisted that the David's Fork Church had failed in its scriptural duty to settle member disputes. The church's decision, in his view at least, was compromised well before its official decree. He charged that from the beginning of its proceedings, the church had erred in handling the case. At one point during the trial, Foster had reportedly flown into a violent rage, and for that action alone, Creeth exclaimed, Foster should have been marked and turned out of the church. The church instead pronounced Foster innocent on his own bare word and without evidence, and contrary to all the laws of all civilized countries and contrary to all Protestant Christendom, had retained him in the fellowship. Only after declaring Foster innocent had the church even asked Creeth to send any evidence to the contrary. And the timing of this request unnerved Creeth, who said, can such a church be called a habitation of justice? What if a state court should give a verdict first on the accuser's word, and then 7 months afterwards call for evidence? What would the community say of such a court? And furthermore, whose character or property would be safe in such hands? So the church, rather than upholding scripture and fairly resolving her members' disputes, had failed to properly pursue justice. I have begged this church to settle this matter, Creeth exclaimed, but she would not. And Creeth would go on. The church's decision, this is a 16-page pamphlet that you see here that he published regarding the actions taken by Henry Foster and the David Forks Church. He said there was larger problems within the church itself, and these problems made it difficult for the congregation to solve this dispute, or any dispute really. Covetousness and speculation was two of the central charges that Creeth had leveled against Foster. But he said that the whole church had become too covetousness, and that they were a nest of traitors and southern speculators, as he called them. He alleged that with his character in question, that the church could no longer judge objectively. And what's really interesting about this pamphlet is the way that he contrasts, as you see, the operations of the church tribunal through this disciplinary process with so-called the courts of the country. What if state courts did this? What if state courts called for evidence 7 months after decreeing a decision? So by doing that, he implicitly raised, the quote, civilized operations of the Commonwealth's courts, of the local and state courts, over that of the church body. And since his former brethren at the David's Fork Church seemed reluctant to sufficiently investigate the matter, the feelings may have been widespread throughout the church. Now, one of the interesting things about this too is the year that it's published is 1840. And one of the arguments that I make is that you see cases like this in churches less and less, especially after 1820. Now, Creeth was obviously upset that the church ruled against him, and that certainly would have influenced his charges and that he made against Foster and other church members in this pamphlet. But as chapter 3 demonstrates, and chapter 3 is sort of framed around Creeth and this dispute, and then also some other ones that took place in the area at other churches. But as this chapter demonstrates, witnesses, observers, and participants across the Trans-Appalachian West echoed Creeth and his accusations against their local churches. In my data set, which I'll show you here in a little bit, reveals a steep decline in business or property-related disputes decided by churches, especially so after 1820. And what this chapter ultimately demonstrates is how the expansion of a market economy and the need for a formal and predictable legal outcome in a case hindered churches' ability to effectively arbitrate member disputes. Now, by the time that Creeth had leveled these charges in 1840 against his church, his former church, he had already aligned himself. He had already been a well-known reformer as part of an insurgent religious group known by a few different names, but the Stone Campbell movement is sometimes referred to as the Restoration or the Reformation. And this movement had wreaked havoc on Baptist churches, especially in Kentucky, but throughout parts of the Trans-Appalachian West since at least the early 20s. And this was a movement led by Alexander Campbell and Barton Stone. Stone, his roots in Kentucky go pretty far back. He was involved in some of these early camp meeting revivals around the turn of the century. He had been run out of the Presbyterians because of some of his unorthodox views, and he had gone on to become a leader of what was known as the Christian movement. He advocated to get rid of all denominational names, right? Come together, Christian Union. We're all Christians. We can find a place at the table for everyone. And then Campbell is a Scots-Irish immigrant who shows up around 1810. Him and his father formed some churches in what's now West Virginia and Pennsylvania, I believe. And then he makes his way into Kentucky in the early 1820s, and he begins preaching at, I think he preached at the first church of Lexington, like 1823 or something. But his doctrine really caught on in Kentucky, and throughout the 1820s, in the early 1830s, you see Baptist churches just dividing. I mean, dozens of them, individual churches, their governing associations. Baptist periodicals of the time are filled with accounts of, Campbell and the destructiveness that his movement is causing within the group. And one of those folks that really did not like Alexander Campbell or Barton Stone was John Taylor. And this is all the focus of chapter 4, by the way, is the Campbell, Stone, and religious controversy and how that affected church discipline. Now, John Taylor, as you see here, longtime Baptist, he shows up in Kentucky in the 1780s. He's very instrumental in founding several churches, dozens of churches, probably over a dozen churches, and a number of governing associations. He's also fairly prolific, and so we know a lot about his views. And in 1830, which at this point, he would have been probably in his 70s at least, when he published this History of the Clear Creek Church and Campbellism Exposed. And Clear Creek Church was in Versailles, I believe. And you can see here that he says that Campbellites seem very church hungry. If they cannot get a whole one, they will put up with a scrap. And, you can really look at this in two ways. At this point by 1830, again, churches were dividing and whole church majorities were leaving. They're saying we are more aligned with the restoration led by Alexander Campbell and Barton Stone, or they were being kicked out by church majorities. Factions were being kicked out, and so membership numbers and local churches and governing associations were in flux. So that's one way to look at it. The other way to look at it is that they are actually battling over the church itself, the meeting house itself, who gets to retain access or control to this physical space that we all worship in. And that is the focus of the final chapter of the book, chapter 5. And this really, this tension between Campbell and the Baptists really comes to a head in these disputes over church property, as I show in the book. And in May of 1834, John Curd and 21 members of this Mount Vernon Baptist Church of Woodford County, Kentucky, they show up to the meeting, and they produced a remonstrance criticizing past actions taken by their pastor, Dr. James Fishback. Now, Curd and his followers insisted that they must withdraw from the church body, and that since they possessed equal rights to the meeting house, they intended to continue using it for worship. Pastor Fishback responded that Curd had ignored church rules and that he was seeking to organize a new church consisting of the disciples of Alexander Campbell and Barton Stone. And although 12 of the dissenters accepted dismissal on good terms from the church, Curd and a number of others refused, and the church excluded them for, among other things, breach of covenant, fomenting division within the church. And days later, Curd and his fellow dissenters who had been kicked out of the church along with a new pastor, forcibly entered the meeting house, according to Fishback, and declared that they had formed a new congregation. Over that summer of 1834, the two factions fought for control of the meeting house, and they eventually engaged in a lengthy legal contest, one which produced much testimony from church members and neighborhood residents, like Rodham Rout, who you see here, who said in his deposition, "I'm not a member of any church, but I can tell you that whatever's going on over there there's some hostility," right? Now, the failure of Mount Vernon members to manage this internal dissension amongst themselves led to a long struggle over this meeting house, and the contest would navigate from extrajudicial arbitration, where each side picked representatives to try to work out a deal. It went, that didn't work. It went to the local chancery court. And then it culminated with an 1838 decree by the Kentucky Court of Appeals, which at that time was the state's highest court. That case came to be known as Curd v. Wallace. And like several similar cases in pre-Civil War Kentucky, this case demonstrates an often overlooked link between church and state during the post-establishment era, during this era where we don't have a church-state establishment. And even without a legacy of church establishment, state governments still did influence religious groups through legislative enactments and court rulings. And amidst this presumably free religious marketplace, one often characterized by dissension and church schisms, actions taken by both religious and state actors opened the door for the latter to shape ecclesiastical affairs. Now, during this time, different denominations often shared, or at least up until the 1840s, different denominations or religious groups often shared access to meeting houses. So you would have, the Methodists might meet one day, the Baptists might meet another, and the Presbyterians might meet another, especially in rural areas. Now, of course, in someplace like Lexington, you're going to see these sort of denominational specific structures, church buildings being built over time. But in a place like Versailles, where Mount Vernon is, that was not necessarily the case. And a recurring sentiment expressed by churchgoers and other observers was that these buildings or property in question were often Republican in nature. And, Pastor Fishback claimed that many such structures in Kentucky, but not the one at Mount Vernon, were built as Republican meeting houses, free for everybody, or for preachers of all religious sects to preach in. In a different legal case over a meeting house in Bethlehem, Kentucky, one respondent insisted that all denominations of Christian Baptists, as well as others, were permitted to use the house until the exclusive use of it was claimed by the faction that this person was in court against. Other observers claimed that, it had to be open to all, because if we were going to build a meeting house, we weren't going to get enough money if we only let Baptists worship there, or if we only let Presbyterians worship there. And some of these quotes, these are all from, except for the last one, all from court cases, testimony. And you'll notice, though, that the second one in Lancaster, it's a case from the 1850s, I believe, that one respondent testified that the house was built for all denominations except for Roman Catholics and Shaker and Quakers. And so, though these meeting houses were often shared by various religious groups and at least nominally available to all denominations, this spatial ecumenicalism, if you want to term it that, had its limits, and groups deemed disorderly by the majority of folks, like Catholics or Quakers, were not allowed, or, as you see in this final quote here, Mormonites or followers of Matthias. Now, there's a few ways that churchgoers try to exclude so-called disorderly groups from their meeting houses. One was through these subscription papers. So they would circulate through the community saying, donate money, here's who can worship in this meeting house. But land deeds and common understanding also dictated the bounds of this religious tolerance in post-revolutionary United States. For instance, Here's a land deed from 1817 from one Emmanuel Skinner, who donated a piece of property for the Spring Creek Baptist Church. And within this land deed, he spelled out 11 different doctrinal positions that that church must adhere to. And if that church decided to, embrace a different theological position, then they could lose access to the meeting house. And for a church or for a denomination like the Baptists, which is congregational, and the church majority theoretically is with the church member, or the church power is theoretically with the church majority, so they could vote on what theological principles they want to follow. If their use or control over property is tied to a specific principle, it could hinder that willingness to jeopardize their material comforts to follow their faith. And there are some instances where churches actually said, should we go ahead and adopt our old constitution so we can keep this property, or we can get our old property back? Now, one prominent example is not from Kentucky. I hate to stray outside the state lines here, but we're going to for just a moment, is in Nashville, Tennessee. Now, in 1836, or excuse me, in the late 1820s, an overwhelming majority of the First Baptist Church in Nashville departed from Orthodox Baptist views and became followers of Alexander Campbell. A small minority of the church, I think it was only like 7 or 8 members, left in 1828, reorganized themselves as Nashville's First Baptist Church, and for 6 years campaigned for rights to their former church building, which they believed they rightfully had control over. And when these efforts failed, realizing that they had no legal character, they weren't recognized as a group in the eyes of the law and thus could not claim that former property, they eventually raised funds for a new building. And this time they ordered the trustees to insert the church majority approved confession of faith into the Constitution and the title papers, which you can see here. And what this basically says is that if at any time the church majority departs from its current theological views, that the trustees will hold this property until a different church adopts these views, and then that new church can have it. And again, for Baptists, that could limit the power of the church majority to determine their own theological course. So there were different ways, from subscription papers to land deeds to inserting declarations of or confessions of faith into title papers. And then one of the big ways that I look at it, how state authority could influence or shape ecclesiastical matters, was a law passed in 1814, which is unique to Kentucky, at least the way that, from my research and the way that it was written, is unique to Kentucky. And in 1814, the state legislature passed this law, which provided a framework for Christian groups only to create a board of trustees and create a legal identity for their organization. And it forbade those trustees from disbarring schismatic groups from meeting houses unless they had been excommunicated for, quote, immorality. So the trustees of the meeting house were not allowed to kick Curd out necessarily in the fishback dispute unless he had been convicted of immorality. And in the Kentucky Court of Appeals case for Curd versus Wallace in 1838, Justice George Robinson granted the schismatic church led by Curd proportional usage based upon how many members left with him. But this, of course, touches on one of the act's potential problems, specifically its first proviso, which mentioned immorality, is who defines immorality? The judges, the church body. Fishback claimed that Curd and his followers had acted immorally when they fomented division within the church. And he went on his very lengthy testimony in this case by saying immorality is meant any act, conduct, or practice which contravenes the divine commands or the social duties of the church members. So this kind of goes back to James Madison's fear if we had allowed an established church as well. We don't want judges trying to determine who are true Baptists and who are not. And that's what you see in a lot of these church property cases that reach state courts, was judges wading into these very thorny theological matters and sometimes being reluctant to do so. Now, in the end, what this chapter argues is that neighborhood meeting houses served as important sites for individuals' spiritual and social interaction. And from the earliest days of settlement, churches looked to the state in order to claim and maintain their property. State authority worked in subtle ways to shape religious matters, whether through incorporation or stipulations in land deeds and subscription bonds. Legal authority protected churches' temporal property and implicitly constructed the boundaries of sacred space, upholding communities' understandings of religious orthodoxy while barring others from these so-called Republican meeting houses. Rather than moving in clearly defined and separate spheres, as Justice George Robertson would claim in a later church property case, church and state, religious and civil authority often crisscrossed during the early Republic and antebellum periods, and Baptists especially, but other religious groups as well, prided themselves on their autonomous natures. By seeking out state assistance, Baptists who had fought so passionately for the separation of church and state during the Revolutionary era inadvertently opened the door for civil authority to shape ecclesiastical matters. Now, before I finish, I did just want to show you, so I mentioned a data set before, and so the book, while it has a lot of qualitative evidence like these cases or like Creeth's case, it is based on the data set, and much of this work was done at KHS with the various church record books, like the Bryan Stations Baptist Church. And so I looked for churches that were located within this bluegrass region, which had records that stretched for decades, hopefully the whole time period that I'm looking at, but at least for several decades. And I looked at the year and month in which these different cases came before the church, the type of dispute, what was, was it drunkenness? Was it adultery? Was it something else? Who brought it? Who was it against? What was their sex, race, and status? Were they enslaved or were they free? And then ultimately what the outcome was. And so I think there's about 3,000 of these. And that's my quantitative database that allowed me to make arguments about, why, how discipline changed when it came to women or household relations or African Americans, as well as in chapter 3, when I mentioned that there just became a less and less number of cases dealing with property matters, for instance. This is what that's based on. So yeah, a lot of time sitting at the tables at KHS after a lunch next door, going through these databases. But so that's all I've got for you this afternoon. But thank you for coming, and I'll answer any questions. Oh, I do have. Here's the Mount Vernon Church today, which my last research trip I went and visited. I actually met the pastor, and he's got some church books. And I told him, you need to reach out to KHS because he's got books from the 1830s just sitting in a desk in there. So, it's a beautiful church, though, beautiful surroundings. And then also, if anybody's interested, and I can maybe send this to Carol if she wants to send out the promo code, but yeah, I'm happy to answer any questions if there are any.
Thank you very much. And yes, I will be happy to send out that promo code if anybody is interested in that. I think I am for sure. So kind of a church history nerd. And so please feel free to put any questions that you might have in the chat, or I think we're a small enough group today. If anybody wants to unmute and just jump right in, you sure can. I'm kind of curious. I'm just going to go ahead and get us started. You talked about Alexander Campbell, and I've heard that name, but I'm not familiar with what his what was it that was so controversial about his beliefs? What did he?
Well, it's funny when you read some of these church property cases, people will be like, well, what is it about Campbell or the Campbellites that so upset you? And they're like, well, I don't really know their doctrines, but I know they're not Baptist, and what Campbell did is he stressed, from my understanding anyways, he stressed the New Testament more than like Mosaic law that Baptists at least were at that time were focused more on. He like a lot of these religious innovators of the post-revolutionary period was focused on the individual more than the collective will. And I think ultimately it was just because he was popular and he was charismatic and he was incredibly smart. I mean, there's incredibly smart Baptist preachers this time too, but Campbell is one of these guys that was so prolific. Had numerous newspapers that he edited and wrote most of the stories for. And I can't, maybe somebody has done work on this, but there's probably something really interesting about the demographic of people who were leaving Baptist churches and joining the Campbellite factions, whether it was an age thing or, again, so much of this is local knowledge sort of in that congregation. Maybe this family didn't like that one. Oh, we're going over to the Campbellites. And, but yeah, I hope that answers your question. Again, I'm not a theologian, so the theological niceties are not always my closest. I'm Catholic, so I'm one of those that would not have been allowed in the meeting house.
I grew up Baptist and married a Catholic, so I'm right there in the middle of everything. I do think we had a question in the chat here. Let's see, let me pull that up real quick. Michelle wanted to find out quick thoughts on women in chapter 2.
So there's kind of a couple schools of thought on women in Baptist churches during this time. One will stress that churches allowed women a greater degree of power than they would have found in other aspects of society at this time, which is true in a very small ways. You would have seen, some churches were very radical when it came to racial and gender relations and allowed women to vote in church majorities and stuff. But the general arc of the story is that as Kentucky sheds its sort of frontier fluid beginnings and adopts, as Craig Thompson Friend would say, sort of the ideals of the Old South state and the hierarchies, the racial and gender hierarchies that came with that, churches sort of followed suit. And so I look at different cases that dealt with divorce, which was rare, as you can imagine, but Kentucky actually had some early divorce legislation that gave women, a little bit more navigation through that if they wanted to get out of a troubled marriage, and how Baptists reacted to that. And ultimately what that chapter looks at is the way in which discipline against white members declines and disproportionately focuses, especially on sexual offenses towards African-American members. And so I look at how that plays out and how these cases of separation between white couples is not really taken up anymore by the 1820s and 1830s, but you have a slave that's sold from Kentucky to Alabama, and then their spouse back in Kentucky is charged by the church with adultery for taking up a new partner. So that's kind of the focus of that chapter, trying to tease out the differences between in a group that claimed spiritual equality, right, with all members, but then inherited these social markers of status, like, that prevailed in outside the church walls.
Right. And if anybody
that
else,
was my hardest chapter 2. I saved it for last, so it was hard.
Understandable. If there's anybody else that would like to submit a question in the chat, please feel free to do so. I was also curious about, I know like early on in the presentation, and a particular case study that you were talking about, where the gentleman was very critical about the church and how, what if a court didn't, tried to do it like this and didn't follow procedure? Was there any kind of procedure that churches followed at all, or was it very just,
So part of that chapter looks at the procedure. So it was based on discipline. There's a few different scriptural justifications for discipline in Matthew and in Corinthians, and how church members are supposed to go about this. But over time, you see this effort to sort of formalize. I mean, there's a series, dozens of publications that come out. They're like, this is how you do discipline. And so that's part of my argument, is that basically church leaders are seeing that discipline is waning because it's not predictable. The procedure is all out of whack. And so we need to, and meanwhile, you have legal changes that are adding to this as well. But I think Creeth was, he was upset. And so he made some charges, but they're echoed in all sorts of cases. That chapter has 4 or 5 specific cases that I sort of look at, and they're all pretty similar.
Okay, well, thank you. Well, guys, I don't see any more questions in the chat right now, but please do feel free to jump in if you would like to. But I will go ahead and close us out for today. Thank you all again for coming and hanging out with us. Thank you so much, Dr. Perry. Great to see what you're doing with KHS resources. I am super impressed by your spreadsheet there. Looks like you had quite a bit of data there to work from. Again, please join us next month as we hear from Dr. Crystal Webster. Thank you all again. We'll see you next time. Thank you so much, Dr. Perry. Looking forward to reading your book.
Thanks. Yeah, I did. I told them to send one to KHS, so hopefully they do.
Okay.
Hopefully send a couple.
Awesome. I'll go steal it from Stephanie.
Yeah, she should have one. She'll find somebody good to review it.
I'm sure she will. All right, guys. Have a good afternoon.
Take care. Thanks.